Yes. Jump. Item number 1.
Lord, in item 1, I appear for the petition.
Yes.
My lord, the proceeding was started, my lord, under the corresponding sections of the Sanhita, corresponding to, my lord, 498A, 306, and 34 of the IPC, my lord. My lord, subsequently, charge sheet has only been filed under section 80 of the Sanhita, which corresponds to 304B, that is dowry death, my lord. Now, my lord, I am the father-in-law, and my lord, my argument, Lord, in the intervening period, the husband has been granted bail by the learned trial court. My argument is there in the bail order itself. Kindly takes up, my lord, the third paragraph. Learned public prosecutor. Third and fourth paragraph are my specific arguments, my lord. Now, the paragraph starts with learned public prosecutor. That and the paragraph after that.
What is the cause of death?
Cause of death is lordship, antemortem hanging.
Hanging.
Hanging, yes, lordship.
Obviously, in the matrimonial.
Yes, they were married about 8 months,
Yes.
and the victim was only 19 years old. There are two 164 statements that is stated in the order sheet also, lordship. The mother and the
Mother and?
Mother is a neighbor, my lord.
Mother is a neighbor.
Yes, my lord. The
mother and
wedding
one
happened and the marriage happened in the next door with the next door neighbor.
mother and the neighbor, lordship.
My lord, it talks about relentless torture, but there is,
I'm not able to read the FIR.
my lord.
21-10-24.
Yes, 21, 10, 20.
I need a translated copy, otherwise.
Lord, I shall provide it
Lordship,
tomorrow.
actually, the thing, the FIR, I have one copy, lordship. It is the memo of evidence. They have summarized the FIR.
No, I don't want to rely on somebody's summary. I
Lord,
want to
I'll-
see what the informant has
Yes, yes,
said, then
I'll translate copy, I'll provide tomorrow.
can you come with it tomorrow?
Yes, ma'am.
So not today will do?
Yes, yes.
Yes.
And the 164 statements also, it is in Bengali, lordship. Should I translate it? lordship?
Please.
2 years, lordship.
Otherwise, how will
Yes,
I
yes, yes.
consider?
Yes, yes.
In the DB, there is no problem because at least brother
Yes.
is there to it, but this I'll need. So tomorrow for giving translated copies of the FIR and statement under 161. Stop, a comma, prayer is made for it, password, for adjournment for the day, stop, matter stands adjourned for the day.
Deeply obliged.
Number 2. For item number 2, I'm praying for day after tomorrow.
Why, what happened?
In this matter, Mr. Guho is appearing on behalf of the petitioner. His brother is admitted in the hospital, my lord. For this, I'm praying for day after tomorrow. If he is not come, I will make alternative arrangement.
In this FIR and all is in
I don't think so, my lord. I will translate, my lord.
all these matters FIR in Bengali.
FR in is Bengali, in all the matters.
No, it's in Bengali. Yeah, we have
It's
to
earlier,
transfer.
it has been rejected.
Yes, Lordship. Earlier it was rejected. Yeah. So,
How second anticipatory bail you have filed?
I think there is a change in circumstances, my lord. Mr. Guho is appearing, my lord. He will apprise your lordship, my lord, about the change in circumstances.
The anticipatory bail application of the petitioner was earlier rejected on 5/12/24 in CRM within bracket 8 944 of 2024. Stop. for addressing this code on the issue of the maintainability of this second anticipatory bail application. An adjournment is sought for. List on, give the date of day after tomorrow.
Grateful lordship.
I am for the state reports. I'm holding the CD. Has the service been affected on the? Yes, sir. So not today, let him be here. I'm grateful. State, your state.
Lordship, I'm behalf of the state. Lordship,
Not today.
Number 5.
Not today.
Item number 5. Item number 6.
Lordship, praying for next week, Lordship.
Next week. As prayed, list after 1 week.
Item number 7. For item number 7 and 8 and 9, Mr. Gu is appearing, paying for day after tomorrow.
Let us see one by one. As prayed by petitioners council, list on 23rd.
number 8. My lord, same prayer.
Yes, same order.
Item number 9. My lord, same prayer.
You give a translated copy of the FIR.
I will come with the translated copy.
Counsel for the petitioner prays that the matter be taken up on 23. Stop. Let a copy of the translated copy of the FIR be submitted on that date after due service upon the Learned State Council.
Item number 10.
My lord, item number 10 and 12, I'm praying for next week.
Next circuit.
Next week, my lord, next week.
Yes, Learned Counsel for the petitioner prays for an adjournment of the matter to the next week. Stop. List after week. On that date, a translated copy of the FIR be made available for consideration, comma, after due service upon the State Council.
Grateful, my lord.
Item number 11.
Madam, this is my application. My lord,
Lordship, praying for short passable, Lordship.
Yes.
my lord, kindly see the last order passed during the last circuit also, my lord.
Where is the question of anticipatory bail if there is a notice under 41?
My lord, what notice was never issued, my lord.
There is a direction.
Lordship,
My lord, there was a direction,
in this case,
the last
Mr. Saurabh
week also,
Ganguly would appear in this matter.
my lord, last
Sir,
circuit
what,
also.
what anyone will do, there is a direction, whether you have complied or not, that is all that
Short
we.
passable, Lordship.
My lord,
Tomorrow,
no,
come tomorrow, not today. We hope that, I hope that you comply with this.
Grateful, Lordship.
Yes. Not today. Simple, not today, we'll see tomorrow.
Grateful, Lordship.
Number 12.
As paid by Learned Counsel for the prisoner. List after 1 week.
Item?
Item number 13.
The copy to the server is not server document. It is in a transition, we have posted it here.
Let it be fixed tomorrow. Victims already served, 13 and 19 same matter, already served. Served, already served. Yes.
On behalf of? Oh, so
They're already served.
in both the matters, So tomorrow,
tomorrow.
not today.
দিয়ে দাও নাম দুইটা রেখে দিলাম। 13
Excise matter, my lord, anticipatory bill.
Which matter?
This one, 14.
What is the issue?
Excise, Bengal excise matter, my lord. Recovery of huge quantity of spurious liquor recovered from a godown. He is the leasing.
Not today, let him be.
Okay. This is the translated copy of it.
You have served a copy.
So for the case is concerned,
Yes, sir, just one minute.
Lordship kindly,
Madam, can you see the FIR?
Lordship kindly,
May I?
yes, please.
So for the case is concerned, enter allegation against Vishnu Pada Sarkar, who is in custody. Now, Madam, kindly see the page number 12.
And who are you?
I am the wife of Vishnu Pada. Wife of Vishnu Pada and son of Vishnu Pada. Kindly see the.
She was not on the Toto.
No. Madam, can you see the page number 12? One accused person, the owner of the Toto, who was not present at the relevant time, was enlarged on PRS bill by the Honorable Court and Bench. That is page number 12, madam. Only guilt they have committed, they are the near relative of the crime.
What is the injury on the child?
Lordship kindly see the medical expert report, Lordship, which is in page 77,
Now,
Lordship.
was the incriminating
And-
admittance against me?
Lordship. The petitioner is the husband, Lordship.
Petitioner is the husband, no, no. Petitioner is the wife of the prime accused, that is the husband.
Yes, that is what I'm doing.
Accused is the husband.
Accused
Accused,
is the husband.
prime accused is the husband,
Yes, Lordship.
not the petitioner.
No, but does the FIR say that when he was taking the child, his wife was also accompanying?
No, Lordship.
Is there anything in the investigation to suggest that she was there?
No, Lordship. Lordship, kindly look into 161 statements, Lordship, which shows that there were personal grudges, Lordship.
Personal grudges of Vishnu Pada, who is in custody. The person standing on a similar footing. Was the privilege of PRS bail by the.
The other two children have not sustained any injury.
No.
Yes, where is the 161?
Lordship, 164 is in page 37, Lordship. 37 and 109 and 110.
164
Yes, Lordship.
page.
Page 37, then 109 and 110, Lordship.
They were not on the queue.
Whose statement is this?
Of the deceased's mother.
How can I read this?
Can you read out?
Lordship, I can read out.
You can read, but I have to understand.
The charge sheet has been filed.
Lordship,
That's all right, but there is a statement, I must see it.
Lordship,
110 is also in our vernacular, so how can I?
Lordship, I can translate, Lordship.
Just come back tomorrow.
That's-
Not. These 3 pages getting translated. There's not much, very small.
Yes, Lordship.
You can also. Oh. Yes, next. No, no. What this? Not today. Either you start or not today. You can start, your senior will come or not today, as you like.
He's coming, Lordship.
Or not today, call the next case.
Item number 17.
I put the de facto complaint.
Actually, this is second application of anticipatory bill.
None appears on behalf of the petitioner. List on give the date of Friday.
Friday, man. Only it's on Monday, man.
Why?
Man, Friday, I have to go on taste, man.
All right. List on give the date of Monday.
Monday.
Grateful.
Grateful. Grateful. Grateful.
Item number 18.
My lord, I am for the petitioner, my lord. My lord, in this matter, my lord, though the affair is in, my lord, in Bengali, but my lord, I have annexed the charge sheet, which appears from the page 13 onwards. My lord, it is completely in English, my lord.
My lord, and on top of that, we don't have the case diary, and I need to translate certain documents, so I need 1 day's time, 1 or 2 days time. Kindly
And
fix it on Wednesday,
de
Lordship.
facto complainant is
De
appearing.
facto complaint, my lord, the state was.
There was a
directed-
direction upon the state to inform through police station to the de facto complainant, but that has not been complied till date.
That has been complied. That has been complied, Lordship. Now we have informed the registrar to appoint a DLSA lawyer for the victim, Lordship. So we have already intimated the patient. Lordship, Thursday. Can be fixed on Thursday.
As paid by land state council. For giving translated copies of the documents, comma, to be relied upon. Matter is adjourned to give the date of Thursday.
Deeply honored.
Item number 19 and item number 13 relates to the same case, Lordship. So they have prayed for not today. Kindly fix it not today, Lordship.
Not today, yes, that matter also we have.
Thank you.
13 and 19.
Item number 20, I'm for the petition, because I think the video service and the translated copy of it.
Wait, नहीं तो. No, sir. My lord, kindly fix it not today, my lord. Yes, my lord. My lord, I need to check, my lord, because in this case, Mr. Abhijit Sarkar is there, my lord, he's engaged, so kindly fix it. I'll just ask him whether he has complied or not, my lord.
As paid list after 1 week.
It is to be- কত আঠাশ
Number 22, I'm paying for 2-day accommodation, I need to be fixed at 23rd.
23rd. As paid 23rd.
Item number 23.
I'm praying for day after tomorrow.
Yes, same order, 23rd.
Item number 24.
For next circuit, Your Worship.
As paid list in the next circuit.
Item number 25.
I'm paying for 1-day accommodation, Lordship.
Not today.
Grateful, Lordship.
Number 26. Item number 26.
None of yes, list in the next week.
26, Lordship.
Yes,
Paying for respondent, Union of India.
none appears for the petitioner list in the next week. For the next.
Item number 27.
None appears list in the next week. What?
My lord, item number 24, my lord, I was on next before.
It has been adjourned. 24.
If it would be next, not this circuit, my lord. My lord, because a negotiation between the parties are ongoing, my lord.
You want 24 to be?
Out of the list, my lord, with liberty to mention.
You are for the petitioner?
I am for the petition.
What is 24? What
My
happened?
lord, it is an arbitration application.
Already it has been adjourned to the next one.
Item 27, I am for the petition.
You are for the petitioner. Call, give.
Well, the respondent was directed to file an affidavit.
Not filed.
I have not been served with a copy, my lord.
Where's your friend?
Mr. Arun Kumar Sarkar.
Where is your friend?
Arun Das sir. वही पता है my lord, Falcon.
The issue is whether he is functus officio or not.
My lord.
The only issue.
Well, it is an arithmetical correction that we requested for.
No, but they have objected that now the arbitrator is
Yes, my lord.
Functus officio now.
But my lord, I will demonstrate before your lordship that there are two judgments, one of the coordinate bench of this honorable court and. that
Can
of
you give
Sup-
the judgment, right?
But let he file his affidavit.
What affidavit? It's an issue whether in law there's a scope for correction of arithmetical error or not.
Right.
That the nature of objection being raised by him has nothing to do with facts.
No, my lord.
So whether the jurisdiction remains, there is any residual power in the arbitrator or he has become functus officio.
Lordship, I
Now he
will humbly
cannot.
submit that there are two judgments supporting my contention.
Therefore, can you give the citation?
My lord, I was under the impression that today the affidavit will come, my lord will take it up for hearing in next day. So on that day, I will produce the judgment.
Can you give us the citation today?
I will give it to officer. Give the citation. Print out it.
As per the last order, the respondent was required to file affidavit in opposition, comma, which has not been filed. Stop. There is no representation on behalf of the respondent when the matter is called on, comma, nor there is in prayer for adjournment. To stop list on Monday. You give the citation.
Lordship.
Let counsel for the
My lord, if,
question is present.
my lord, if kindly
At the top.
permits me to mention before lordship, item number 26. And that we respond. Well, there was a direction to serve copy on us. Also. Or copy on us. My lord, it is adjourned to next week. Yeah.
Not today, not. What is there, what is the correction? Any correction? Only year. Which year? Oh. Yes, you are appearing.
Chief item number 2.
24. Where it is saying 24. 4 of 20. 41 of 20. I don't know how many numbers are there. There are two first appeals. There are two first appeals. The 24 is also here. 4 of 22. This file is having a 84 also. Section 84, not 84. Let them be. Not today.
Lordship, for item number 2, the conducting counsel, Miss Radhika Agarwal, she is severely ill.
Yes.
So Lordship, she has gone out of station for seeking her treatment. If your Lordship may fix it for next circuit.
Next circuit.
Yes, your Lordship.
I'm representing respondent National Investigation Agency. And this case has been pending since very long. And my officers have come all the way from Delhi NIA headquarters. So I've got objection.
So what do you propose? What should we do today?
It's been pending since January. So many dates have been.
Lordship, in the previous occasion,
Point is, you have made an objection, so therefore we are asking you, what are we supposed to do? Tell us, according to you, how the court should proceed.
Let it be dismissed in that case if
In
they are not
default,
into
criminal appeal.
criminal appeal.
We will. That is the law.
No, it's against the order of bail rejection. In the lower court, the bail was rejected. Against that rejections, they have come up for appeal in this.
Lordship, the appeal was
There is any
admitted.
interim order.
No, there is
No,
no
yeah.
interim
Then
order.
why are you, how are you concerned?
Actually,
They
the
may
thing,
take
my
as
officers,
much time.
my officers
Your
have
officers
come,
are not so important.
they have come
If
all
there
the
is
way
an
from
order,
Delhi.
then we can understand. Your officers may have come. Yes, as paid by Leonard, it is submitted by Leonard Counsel for the appellant. That the Leonard Counsel, who has to appear on behalf of the appellant, is undergoing some treatment for which she is outstate, full stop. He prays the matter be listed in the next available circuit, full stop. We order for listing of the matter in the next available circuit.
Grateful, your Lordship.
Objection to record could be one.
So my objections may kindly be recorded.
Yes, Leonard Counsel for the National Investigating Agency has raised an objection on the adjournment. Yes.
Item number 3.
Lordship, in item number 3, I'm paying for next week, Lordship.
Next week,
Lordship. Lordship, just received the paper book, Lordship. Needs
What is
certain
it?
time to.
what is it?
Lordship, bail in connection with appeal, Lordship.
All right, next week, as paid by Leonard Counsel for the appellant list in the next.
Item number 4.
My lord, item number 4 is the bail application, bail in connection with appeal. Under section 376, clause D, I have to serve copy to the other side, my lord. 376 is there.
Lord, and the application does not contain the Lord judgment, copy of the judgment. Without the judgment, my Lord,
Why?
My lord, then I will also cure the defect. I will provide the copy of the judgment as well as serve the copy. Kindly place it next week. কোন কপিটা ওর? তোমার
জাজমেন্টের কপি নেই এর মধ্যে।
তোমার-
হ্যাঁ।
Actually, also.
আমাদের তো অ্যাপিল বেলটা আলাদা রয়েছে।
There is a delay condonation application also
Delay is condoned, my lord.
already.
Delay con. An appeal also admitted, man. This one for bail application.
The counsel for the respondent for the state submits that the copy which has been served upon the state does not contain a copy of the judgment.
Number 6.
My lord, for item number 6, I'm appearing on behalf of the petitioner. I'm praying for a week accommodation, my lord. I
Why?
will keep the matter on the next week.
Why?
My lord, the senior advocate, appointed advocate is not well, so he wouldn't be able to appear this week. Finally.
Last time you had a sort an adjournment, now this time they are seeking.
And kindly, this will be the last prayer, my lord. Kindly give a week accommodation. Patience.
Number 7.
Good evening. My lord, in this case, we are the appellate. On behalf of Narcotics Control Bureau. The difficulty that lies, my lord, after the respondent was released from custody, he has gone and now staying in Nepal. So service will take, my lord, considerable time because we have to go through the High Commission channel. My lord, this may be for the present delisted. I would the liberty to mention when the service is complete. So, my lord, we are trying to send it through Indian High Commission to Nepal embassy, and there the service will be effective. Department has prepared the papers that will be transmitted from one High Commission to another High Commission. My lord, we cannot control that. Well, we have taken steps. We have prepared the documents to be served, and we are sending it to the High Commission.
Service has not been affected yet, Lord. So I'm praying for 1 week accommodation. In the meantime, it will. Once it was served, but on the last order, again, direction for service was given. I have posted it, so it's quick post. Defect is not said, 108 days delay in preparing the application for leave.
Number 9.
After this is an appeal with a application for condition of delay. We were being directed to serve the application for conditional delay on the respondent, but due to the intervening holidays, we could not effect the service. If my lord is kind enough to fix it any day next week, we will effect the service and come back.
Number 10.
Not today.
Item number 11, and for the number 6.
But I am for one of the respondent, Milord, the primary board.
My lord, I am for the school, district school board Darjeeling, my lord, respondent number 6, my lord. Do we have submission, my lord?
Yes. Affidavits, Milord, are complete.
My lord, we have filed. My lord, though affidavits have been complete, my lord, we have some additional documents which are required for the admission of the letter, my lord. And for the respondent number, district school board, we have to file a supplementary opposition in this field, my lord.
You are not
Kindly
very
allow
audible.
me to file some documents. But, am I audible now?
Yes.
Am I audible? My
Yes.
lord, affidavits have been completed. Opposition have been filed by the respondent number 6. By we have some additional document to file, which is required for adjudication of this matter, my lord. May I file a supplementary affidavit in opposition to bring all the documents on record, my lord? So kindly ask me to file my affidavit in opposition supplementary form, my lord.
You are for respondent number 5 or 6.
6, my lord. I am for the 6, respondent number 6, district school board. That's it.
For 2 and 3.
None appears for the appellant. Respondent number 6 is learned counsel for respondent number 6. Submits that a supplementary affidavit in opposition is to be filed, bringing on record some documents essential for consideration of the appeal. So there is none to represent the appellant. So we therefore adjourn the matter to be taken up on 28th.
Yes.
My lord, in this case, I'm for the appeal. The earlier occasion, coordinate bench was reason upon my prayer with VPS and trying to find an exception to a report filed by the state. My lord, I just pray for a little extension. My lord may fix any date in the next week for hearing of the appeal. In the meantime, I will find the exception, if any, with the advance copy to my lord.
Exception, you are the.
I'm the applicant.
For the private respondent 7.
And rest is.
Earlier occasion, I have preferred and read, and one order has been passed, and that order could not communicated by the BLR, and thereafter another application, they have preferred another read applications and.
No, my lord, it is not that.
And
This
thereafter.
read application that was filed, it was disposed of. Appellant filed a read application.
Disposed of on which date?
My lord, this is an appeal against dismissal of my read by the learned trial judge.
By which, on which date? WPA 8429.
Yes, my lord. Uttam Datta versus State of West Bengal.
So your writ petition is there. Why do you have to file anything?
My lord?
Your writ petition is there.
No, my lord. My writ petition filed by the appellant was disposed of by the.
So therefore, that must be there in the record. Where is the question of any exception now?
No, no, my lord.
Your entire case will be in
I'm
the
telling-
writ petition.
Let me explain it to you, my lords. When the appeal was being heard, your lordships found it was informed that the state has conducted an inquiry. On query by the court, it came out that appellants were not served with a notice of the inquiry. So the honorable court directed that you serve a notice on all the parties and do whatever inquiry you have to do and file a report.
But
So-
that is now something beyond the writ petition.
Yes, yes,
Therefore,
Lord.
we are saying
My lord,
these are all
that
subsequent
was
events. How it is
absolutely beyond the
important.
writ petition. I do not know why the state took out this matter.
So therefore, if there is anything like that, you can always challenge it afresh. That will not in any way affect the merits of
No,
the
my lord, it will
past-
not affect the in any way of my case. Rather, the report, if your lordship peruses, it is in favor of the appellant.
We don't know. It
My
may
lord,
be against
my lord,
you. It
kindly
may be
fix
not.
this any day next week. We will get that.
Don't file any exception. What exception? These events subsequent.
My
to
lord,
this-
I'm waiving that liberty given
Yes.
to me. My lord fixes it for finally.
As prayed for final consideration, matter is adjourned to be decided on 29th.
Yes, my lord.
Conducting advocate could not be able to. One day accommodation.
All right, not today.
Number 15, 14, that's it.
My lord, I'm led by Mr.
14.
I'm led by Mr. Shaptangshu Basu, my lord. Kindly keeps the matter in the next available week, my lord, due to some personal difficulty. My lord, learned senior intends to come to the circuit in person, my lord.
You are for
I'm for the applicant, my lord.
appellant.
Yes, my lord.
We have to respond. Read was filed by the appellant and read was disposed of by his lordship in a single man, holding that the breach of contract, single remedy thanks. Honorable Justice Chanda has held that matter, filed and signed. Even that the appellant, writ petitioner come up.
And there's no arbitration clause in the agreement. Just check up. You want it in the next week as paid by London Council for the absence list on 29th.
Item number 15.
Lordships, I am for the.
Your lordship, I am for the appellant. Your lordship, I am praying for next week, your lordship. Services-
Every matter, there is a prayer for adjournment, either not today, not
Service on
tomorrow, not
respondent
week.
number 4 and 6 is not completed, your lordship. Within this week, it will be done.
The private respondent is there, your lordship. One private respondent.
Four is superintendent of post office.
No, 5, only one party is the private respondent. 6. Respondent number 6, your lordship. Service is not completed.
6, who is the respondent number 6?
Private respondent, your lordship.
My lord, he is the branch postmaster.
He is the branch postmaster. He's not a private, he is pleaded by name, but he has a,
Merited issue.
so you are not representing.
No, your lordship, is the private respondent, the matter is regarding to transfer. And this private respondent number 6 promoted your lordships.
In the place of the petitioner, before it, my lord, respondent number 6 got the benefit of the transfer order. It was challenged by the petitioner before the report.
And it got decided on merit, sir.
And the writ was decided on merit. And my lord, there is a big question mark hanging whether this honorable court has jurisdiction or CAT has.
So that issue has not been considered as yet.
My lord, the writ has been disposed even on a different.
The rate has been disposed on merits.
Merits, sir.
Not on the point of jurisdiction. So how this writ petition was filed with respect to a postal staff?
Your lordship, in the particular rules of the postal department, your lordship, the word is there sevak. And sevak does not falls under a government worker, your lordship.
We have decided this issue sitting here in this bench.
Your lordship, then, your lordship, actually, I am not the conducting advocate. Your
You
lordship.
remember the citation?
Yes,
We have decided this issue sitting here. Please take the judgment. There is a judgment of this court itself. Both of us were parties to that bench. You take the citation, we will consider it. Just give us the case number. An objection has been raised regarding maintainability of the writ petition. At 55, get a printout of map 55. 55, get a printout.
Lordship, item number 60, I am led by Mr. Ankit Kanodia. Is
Lordship,
appearing.
Lordship, I appear virtually in 60.
Yes.
Lordship, it's a GST matter. On 2nd of April, the coordinate bench had directed us to file some informal paper books. But that is not required, Lordship, because every paper is in my stay application is already there. Lordship, this can be taken up for hearing. It's a GST refund matter, Lordship. I am suffering a refund rejection of 75 lakhs. Lordship, if convenient, your Lordship may take it on Friday. I will come and do the matter, Lordships.
You please comply with the order. You please
Lordship, this-
comply with the court's order.
Lordship, the stay application, we mentioned before the bench, the stay application has all the papers before the learned single bench.
You please comply with the court's order. The court's earlier order has not been complied with. The learned counsel for the appellant seeks an adjournment or seeks the matter to be taken up on Friday for final consideration, full stop. Let him comply with the last order and file a paper book. Matter to be listed on Monday.
Grateful to your Lordships.
Number 16.
17.
17, my lord.
Yes.
Learned AG is appearing all right.
Rashmi Ghosh is there, Lordship, of the appellant.
17 Mallet, I am appearing, assisting the learned advocate general Mallet.
Yes.
Mallet, I have a point of maintainability, Mallet. So if your lordship kindly, Mallet, I leave it to your lordship. Whether the lordship would like to hear me first or the appellant first, Mallet.
You are on the point of maintainability of the writ petition or this appeal?
No, Mallet, this is an appeal, Mallet, on the point of the appeal, Mallet.
Kindly does this my appeal.
What is your objection regarding maintainability?
Mallet, my objection is this is from an order rejecting and dismissing an application for contempt. Now, Mallet, I humbly say, Mallet, that no appeal lies from a rejection stroke dismissal of a contempt petition, Mallet. That is only given to a person if there is an order in contempt. And accordingly, Mallet, this contempt is not, or rather the appeal is not maintainable under section 19 of the Contempt of Courts Act. Secondly, Mallet, if my learned friends try and say this is an appeal under clause 15 of the letter statement, with the humility I say it wouldn't be applicable here also, Mallet, because no judgment or decision has been passed by the single judge, Mallet. So, Mallet, I humbly take this point that it is not maintainable, Mallet.
This
Mallet, I would be
not raised earlier in the proceedings.
Mallet, sorry, Mallet. I missed it, Mallet. I'm so sorry.
You did not raise this.
Yes, Mallet. Last week I was there physically to raise the dispute, Mallet. But the other side was not in a position to do the matter. So again, it was adjourned, Mallet. Even when the learned advocate general appeared, Mallet, on the last occasion, or occasion before that, Mallet, we had taken this point. But, Mallet, it was on the verge of being accepted, but thereafter, Mallet, time was short for, Mallet, if I can see the least of that. So if your lordship, Mallet, I have taken this point, let them answer. If your lordship wants, I can
What do you have to
the
say?
judgment also, Mallet.
There is an issue of maintainability. Please address us. on that.
Lordship, on this order, your lordship, may kindly seize, lordship, the order which
Yes.
which is dated 6th of September 2024. Lordship, I'm placing the order.
Just a minute. Let us find the order.
Lordship.
Yes. We'll read. Just let us read.
Lordship, I'm coming to the order.
Let us read. We are reading.
Lordship. Lordship, at the very first, I may indicate, your lordship, I am being led by learned senior Mr. Moinak Bose. Lordship, I am placing the order of 6th September 2024.
We are reading, madam. We told you we are reading. Please wait.
Lordship.
So there was a positive direction to apply the same rates.
Yes, your lordship. There was a direction that the lordship, this was an order passed wherein the honorable court directed that the rates which were applicable for the others has to be also made equally applicable in respect of the petitioners.
26
Now I
June
have come
23.
before lordship.
26 June 23.
Lordship, I beg your pardon, your lordship.
The order of the writ court is 26 June 23.
Lordship. Lordship, thereafter, what has happened, lordship, may I indicate? Now, lordship, thereafter, this rates, since was made
No,
applicable
but we are
for all,
presently on the maintainability.
lordship, I'm
There is
coming
not
to
a-
the maintainability point.
Yes.
Lordship, this order was for implementation of the rates from the dates it was published. That was
That's
the
not
only
the
issue.
point. The point is when the contempt court has not exercised jurisdiction of contempt, whether an appeal will lie, that is the only issue.
Lordship, I'm coming to that. I'm only indicating what the order was passed. My second
Whatever may
point
be
would
the
be
order,
that
if it is maintainable, it is maintainable. If not,
I
then
am
not.
coming to that. Lordship,
The
kindly
merits
hears
of the
me.
order hardly makes any difference to the issue of
But I
maintainability.
will not address this honorable court on merits. On the
Yes.
merits, I'll be only on the point of maintainability. Lordship, the court, the contempt court has entered into the jurisdiction of review of its own order. Lordship, that is where is my point of challenge. I'm not going into the merits. Now, your lordship, a court, an honorable court, sitting in a contempt court, the jurisdiction in contempt is very limited. Now, what has happened? This order has been reviewed by the honorable judge in sitting in a contempt court, your lordship. Now,
According to you,
according
which
to
order
that
has been
section,
reviewed? According to you,
the
which order?
same order which I was relying on, this 26 September, your lordship, this order has been reviewed. Lordship,
This
may
is
kindly
passed in the writ petition.
passed in the writ petition. The order passed in the writ petition, that is of 26 June 2023, was very specific, very categorical. Now, this particular order could not have been reviewed sitting in a contempt court. Lordship, pursuant to that, your lordship, under section 9 of the 19 of the Contempt of Courts Act, my appeal lies before your lordship. That is where the maintainability point is.
So where is that positive? We asked you earlier, we are asking you again. Where is
Lordship,
that positive direction to give a particular rate to the petitioners?
Lordship, I'll be first placing from the order of 26 June, your lordship.
That is the only order we have to see. We have to see nothing more. Now,
Lordship,
in that
then-
order, where is the positive direction
Lordship,
that this
Lordship,
and this rate has to be given to the petitioner? That
Grateful, my
positive
lord.
direction.
Lordship,
Yes.
may kindly takes the application for condonation of delay,
Yes.
annexure A1, page 25.
Come to the order of 26-6. Where is
Lordship,
the
I want that.
positive direction? That is
Lordship,
what we are asking you.
Lordship, 26 order I am only placing.
So we have
indicating
that
the
order.
page number.
That order is before us.
Lordship, may kindly takes page 3.
Yes. Second paragraph, read.
Lordship, page 3, I'm reading. As such, WPA number 1315 of 2023 is disposed of by directing the respondent number 2, that
To
is the health
consider.
secretary such
consider.
and such, to consider the
To
representation.
consider,
dated
yes. So
upon-
there is no
Lordship,
positive
may allow me
direction.
to- Lordship,
Yes.
Lordship, all affirmative, all affirmative.
Yes.
If necessary, upon giving hearing to the petitioners, if
Yes.
necessary, that hearing was not given,
Yes.
and to dispose of the same as expeditiously as possible within 3 weeks from the date of communication of the order to the said respondents. A stop. Thereafter, upon such consideration, the current finalized tender rate shall be made applicable to the petitioners if necessary, by modifying the contract with the petitioners.
Correct,
and
if
possession
necessary.
of the
Therefore,
contract.
again, we are asking you, where is the positive direction? It is also all consider and if necessary. There is no positive and mandatory direction that this and this rate has to be applied. So
Lordship,
upon
that
such
allows me to-
consideration, if necessary, where is the question
Lordship,
of
the
any?
next para, Lordship, the next para.
Yes.
Such effect from the date of
Such
publication.
will again
of the-
relate to the earlier two paragraphs, relying upon
I'll
consideration
relate it.
and.
Lordship, I'll
Yes.
relate to that.
Yes.
Kindly allow me, Your Lordship.
Yes.
Such effect from the date of publication of the finalized tender rate shall be given as expeditiously after the disposal as possible, preferably within a month from the date of such consideration by the respondent number 2. Lordship, this is the ordering portion which has to be relied upon.
Yes.
Lordship. Now coming to that, Your Lordship, this part, the third paragraph, Your Lordship, where it starts with upon such consideration. There was a direction that I may be considered.
So according to you,
Lordship,
this is the
thereafter-
direction, third paragraph is the
Yes.
direction. All
Yes.
right.
Now, if I may be considered, Lordship, thereafter may I read once again, only the third paragraph. The current finalized tender rate shall be made applicable to the petitioner. That is an affirmative direction. That the rates
It
have
stops
to be
at that. It stops at that.
No, if necessary, by
So
modifying the
therefore, yes,
contract.
correct.
Lordship, there is a contract. The
All right.
contract starts from 2019. So the court is of the view, the honorable court is of the view.
Again, you are addressing us on merits. We are asking you to address on maintainability. You are trying to show us that a contempt is made out. We are asking you, the specific objection of maintainability has been taken by the State Council with reference to section 19 of the Contempts of Court Act, and he also says under clause 15 of the latest patent, it is not covered as a judgment. This is the issue we asked you to address us on. You are addressing us as if we are hearing a contempt.
Lordship, I apologize, Lordship, I could not follow your Lordship.
We
I've
have asked
only
you to
read
begin
this.
with. We told you twice that come to the issue of maintainability. You are arguing as if you are arguing a contempt application. So these
Lordship,
are the two objections. What have you to say on these two objections?
Lordship, these two objections, your Lordship may kindly considers, your Lordship, with regard to Lordship, I've been able to make out this case, your Lordship. I'm being led by my senior, Mr. Moinak Bose, who is on his legs, your Lordship. If your Lordship grants a very short passover, your Lordship, let him be allowed, because I'll be
Tomorrow,
relying on some
tomorrow,
judgments.
not today. You come with whatever judgments you want. An issue has been raised
On the
regarding maintainability of the present appeal arising out of an order passed by the contempt court refusing to exercise jurisdiction of contempt and holding that contempt was not made out, full stop. The objection is twofold, full stop. One is founded on the provisions contained in section 19 of the Contempt of Courts Act, full stop. The other objection raised by the learned State Council is that even under the provisions of clause 15 of the latest patent, the order impugned in the present appeal does not come within the expression within inverted comma judgment, full stop. The learned counsel for the appellant submits that her senior has to address this court on these issues. Full stop. Let the matter be listed. Yes, sir. I think tomorrow she may not be able to do it. Just on asking on Contempt. Can you do it tomorrow, or you want 1 or 2 more days?
Lordship, tomorrow or day after?
All right.
Any
No, tell us tomorrow or day after. We are asking you.
Lordship, tomorrow.
All right, as prayed, matter is adjourned for the day.
Very grateful to your lordship, very grateful.
Grateful, my lord. ঠিক আছে, শোনো। যখন ম্যাটার থাকবে
Number 18, my lord, there was a direction to file the opposition by the state respondents. So there's a direction to file an opposition, my lord, take a look at the order, my lord. Find that matter can be taken up.
Yes, what is the improved order? Let's.
Defective marker. Milord, on the last occasion when it was taken up, Milord, the point on which we were arguing, that Milord, the GST Act nowhere bars the respondent authorities in granting a Milord, order of a fresh certificate of registration. I mean, the consequences is very severe because, Milord, kindly presume a situation, I don't continue my business for 3 or 4 years. Now, once my earlier registration is restored, for this interregnum period, I have to bear the financial and penal consequences. And this is the reason this Honorable Court directed them to disclose their stand by way of an affidavit, whether, Milord, revocation of cancellation is the only remedy available under the law, or
Let
where
us see, where is this for, what instruction is it required? Let us see the act and statute.
Yes.
Either there is a remedy or there is no remedy. For what opposition has to be filed?
Actually, there is nothing to dispute.
So let us see.
But kindly, Milord, consider the provisions if
Yes.
Milord desires.
If I may, Malad, the issue relating to the revocation, Malad, that has to be first applied for. He has not even applied for revocation of your.
So therefore, just because you say so, it has to be applied for, or there is a provision that is. So let us see.
Even there's a.
Which provision? Tell us the provision.
21.
Let us see what it says.
Milord would first
Give us
take-
a copy. It says that once it has been suo motu cancelled, it has to be, the only option is to revoke.
Revoke, yes.
Where does it? Please read out.
আরে আমারও তো লাগবে একটাই বই আছে।
Which provision you are relying upon? Give us.
There's also a separate notification to that effect. Malad, I may hand over the copy of it.
You have given us 2 copies.
I have only one single.
No. Please take it back. You are appearing in a division bench, that's not good.
But if I may.
So Lord, if he is relying on something, Milord, let a
Give that,
copy be
give
given
them
to
also
me.
a copy, give them.
Milord,
also.
let him come back tomorrow and argue
Come,
it, because
give us a copy and give them copy. Not today, tomorrow.
আমাকে একটা কি রিলাই করছে কপি তো কি রিপোর্ট
Number 19. 19, Lordship. I'm appearing on behalf of the Lordship, my learned senior friend on the other side, Mr. Omlesha, is for the respondents. Now he has requested me not to only pray for an adjournment because he's feeling unwell. He has left the court. Number 20, Lordship, I'm for the.
Item number 20, your lordship, item 19 and 20 are analogous matter, your lordship. There is a direction to file the opposition, your lordship. So I would like to file the opposition today in the court, your lordship, but unfortunately I have got only one copy, your lordship. Within the course of the day, it has already been affirmed, and I would like to hand over the copy to my learned colleague, your lordship, who is appearing for the appellant, your lordship. Within the course of the day, I would file it in the court, your lordship. And for some reason, there is only one copy, your lordship. It has been missed by my clerk, your lordship. So it has been already affirmed, your lordship.
Lordship. Yes, if your lordship can takes up the order passed by the single judge, it has been said that instead of 11 November 24, because of this, now has continued till May 25. Yes. 16 November 24. Yes. Order was granted. Yes, immediately thereafter we preferred an appeal. Therefore, it has been refused just because this appeal has been filed by now. It would have been decided. No, because this interim order is in the form of final relief. This interim order, yes, kindly takes up the. No, what you kindly do. Does not say that the plan has been sanctioned or anything like that. What is the relief in the restriction? Let us see. Now, if we, now, for. Lead petition copy, I don't, I'm not having the copy. Lordship, for that, I'll be requesting your lordship to take the brief of the previous matter. Both were heard together. Both were heard together. Again, go. Your lordship takes up the impugned order. Paragraph number 37, internal, the last page of the order. 37, paragraph number, wherein the corporation is directed to take a decision in terms of the resolution held in the meeting of the mayor in council on 18 November 2023. Now, if your lordship allows me, I shall demonstrate before your lordship the background of this case. Yes, but you are not going to use the of the report and enter to the merits and decide the issue. No, kindly allow. No, kindly allow. No, what was the, your lordship kindly appreciate what was the decision of the mayor in council of 18 November 2020? No, mayor in council had taken a decision that to regularize the structure on payment of fees. No, that issue has not been decided. But subsequent to this decision, the mayor it was passed on November 2023. But in March, April 2024, the mayor in council understood its mistake that, no, I'm only appraising, I'm only appraising your lordship. We have demonstrated before the writ court. Before the writ court, all the documents were there. We have demonstrated, but in spite of that, this direction has been passed to take decision. You have to take. Yes. If your lordship kindly takes up paragraph number 5. 5. May I read it for your lordship? After getting knowledge that the petitioner started construction work without obtaining the sanction plan, the mayor in council of the corporation in its meeting held on 18 November resolved to impose fine upon the petitioner and thereafter sanction of the building plan. The corporation accepted the retention fees for deviation in making construction on 7. Says, yes. Kind, the next paragraph. In the month of May 2024, the commissioner of the corporation wrote a letter to the joint secretary of the Department of Urban Development and Municipal Affairs seeking clarification with regard to the construction work. This letter was only sent because there was a prior decision. No, there was a. Yes.
So where have you stated that before the report that it was not considered?
But this letter was sent by the commissioner only because. Yes.
Last week you said yes, they are in court. Not there. Let's see if therefore we are. There's nothing, not even a whisper about the mayor in council withdrawing any such or recalling or reconsidering any such. Like the mayor in council, in the other case, he has accepted the fee or.
Yes, in this case, we had accepted the fee, but yes.
They're looking to the record. Not in mentioned.
Now only because the direction was upon us to take decision in terms of the decision of the mayor in council, but the decision of the mayor in council has been subsequently changed. Yes, if you also kindly takes the stay application. Yes, page number, it is at page number 22. The earlier file, page number 22, this is in can 2 of. Yes, it is there on the record. In both the this case also. In page number lordship, you will find it. It comes to page number 21. This is the resolution proceedings of the 20th mayor in council meeting. BOC was held on 28/5/2024. The relevant portion is on the next page, page 22. Point number 5. An applicant named Rajiv Sitlani residing at Meghnad so and so had applied for approval of the building plan for the concerned plot of land, white plan number dated. However, it came to the notice of the SMC that applicant had already erected some structures on the said plot of land. The matter may be sent to the UDMA department seeking necessary guidance. Yes, the proposal was placed and approved. Yes, for sending it to the UDMA, it was placed before the floor of the BOC and it was approved. Then yes, you sent for clarification. This is the proceeding of the
Siliguri BOC held on 28/5/20. This is a mayor in council. Kindly look at bottom portion, Siliguri Municipal Corporation postings of 29th MIC meeting. MIC meeting. And in the first page, at the bottom of the line, and also in page number 21, the first portion, proceedings of the 29th mayor in council meeting. But in the impugned order, we were not allowed a chance to file our affidavit in opposition. No, it's pending. There was no such direction. If your lordship kindly takes up the impugned order in the first matter. Yes. Paragraph number 8. It has been submitted that the aforesaid Obhijit Modak, that's the previous matter, and the petitioner both lie on the same footing, and similar relief may be granted to the petitioner. Only exception is that the retention fees was accepted by the corporation from Obhijit Modak, whereas in case of petitioner, the same has been refused. The instant writ petition stand adjourned till 11th November 2024. The corporation is restrained from taking steps and further steps in terms of the impugned communication dated 26th September 2024, annexed at page 18 of the petition, until further whichever is earlier. So since both are on the same footing, there already order was passed that you take a decision in terms of your resolution of the mayor in council. So this was also, so we had to file this appeal. Abhijit Modak. Both were heard on the same day anonymously. Only thing was that in no, both are pending. Both are pending. Only difference is that in the Modak's matter, the retention fees that was calculated, that has been here it was not, but subsequently before filing of that writ petition, we had given him a letter, you come and take back your money. First day. Lordship. For filing of we'll 10 days maximum will file. 10 days will file opposition. Yes, I am for the petition. Both the appeals we are for. SMC, Siliguri Municipal Corporation is the appellant. Mr. Amlesh.
Not today, it has.
Lordship.
Great.
21.
None appears for the appellant. List on Friday, give the date of Friday.
My lord, I appear on behalf of the appellant, my lord, item number 22. My lord,
Time for the
kindly
respondent writ petitioner.
in this matter, day after tomorrow, Mr. Partho Pratim Roy will be appearing before you physically, my lord.
As paid by learned counsel for the appellant to enable physical appearance of Mr. Partho Pratim Roy on behalf of the appellants, the matter is adjourned. Day after tomorrow.
Grateful, my lord.
Grateful. Lordship, item number 23, I'm led by Mr. Himanshu Kumar. He is appearing virtually, Lordship.
My lord, I beg to appear virtually. This matter heard last 11th March, and there is interim order for 8 weeks. And also there is direction for filing of affidavit in opposition. Till date, no affidavit in opposition filed, and interim order will expire on 11th May. And the next circuit is up to 2nd May, my lord. So I am praying for extension of interim order. My lord.
My lords, I am appearing for respondent number 1, 6 and 7 in this matter for the CGST authorities.
Lordship, I am paying for an extension of 2 weeks. Yeah,
How long it take for filing your opposition?
My lord, the answering authorities are the state authorities, my lords.
Oh. The learned counsel for the state seeks an extension of 2 weeks for filing the opposition in terms of the court's last order dated 11/3/25. So the learned counsel for the appellant submits that the interim order granted on 11/3/25 will lapse on 11/5/2025. So considering the submission of the parties, we adjourn the matter to be taken up in the next circuit.
My lords, our attendance may be kindly be noted, my lord.
The
Respondent number
interim order dated 11/3/25 stands extended by a further period of 8 weeks from date. Second line may just record learned counsel for the respondent. One is represented by Shuli. Yes.
Not extended 8 weeks, my lord.
Yes.
I'm so grateful, my lord. Grateful.
Grateful, my lord.
Item number 24. I am for the respondent number 125, that is writ petitioner's lordship.
Lordship, the advocate on record is out of station for his treatment.
Lordship, from the very first day, they are dragging this matter by seeking adjournment, lordship.
Kindly place the matter for the next week.
From the very first day, lordship, they are seeking adjournment, lordship.
You sought 1 day's time to find out whether it has been complied with or not.
Lordship,
on second
these
of
are the documents
just
that-
wait, on 2nd of April. And thereafter you have taken 2 adjournments.
Sure, I'm praying for only 1 week accommodation.
Sorry.
Kindly, Lordship.
Please proceed.
Lordship,
We
I
are
have
not
not been
going to grant
instructed by
any
the
further
learned.
any adjournment.
Sure, actually, I have not been instructed from the learned
And
advocate.
tomorrow, not today.
Obliged, lordship.
Item number 25.
We are for the state, madam. Oh, following.
Lordship, very hesitantly, I asked my lords to fix it tomorrow.
What happened?
My lord, to be very frank and honest with the court, I missed out the matter.
Not today.
Grateful.
Item number 26.
27, my lord, 26 and 27 are identical items. Paper book is ready, my lord. We are submitting the paper books and
You already filed.
that's right. And my lord, we just want to cause service upon the respondents
Service.
of the paper book. We have to serve it upon the state because additional district magistrates. But basically, it is an appeal against an order passed by the district 34 court.
So this is under 37.
Lordship.
So they are represented.
My lord, I am the respondent in item number 27.
So therefore you have to serve on them only. So you're representing respond number?
2 to 25. In
25.
case number 2.
Case number 2.
Arbitral award number 2.
My lord, actually, it's the land acquisition matter. They are the persons from whose land was acquired.
This is item number 26. Which respondents you are representing?
My lord, I am not
He's
in
not
item
in
number
26.
26.
Oh, 26, there is nobody.
My lord, they appear to-
26, 27 will be called, then you will. Yes.
Well, in 26, private respondents, to my knowledge, has not appeared.
And what was can one filed for?
For stay, sir,
Stay.
disposal হয়ে যাচ্ছে, merit একসাথে disposal.
That was, no, honorable court held that it could be taken up at the final vote.
So why these two matters are together?
Similar nature, my lord. There were 2 awards passed by the learned arbitrator. They were challenged.
In
before the-
respect of two different contracts or agreements?
No, my lord, it is pertaining to land acquisition.
Oh, land acquisition.
My lord, will find that appeal.
NHI,
NHI DCL, my lord.
there is a provision for arbitration and all.
Yes, my lord. Statutory arbitration, the
Yes.
3G. Against the arbitrator, but we went to 34 court.
So this is all arising out of one acquisition proceedings, but the claimants are different.
Claimants are different.
So they have to be represented. Has notice been issued to them?
No, my lord, notice has not been.
In first case, we don't find any such order.
My lord, we will be directed to serve it on the advocate on record in the 34 court.
Can you do so?
Because my lord, serving about 26, 30 individuals will take a lot of time.
Who knows, once that matter is finished,
No,
their,
my lord, I do appreciate what your lordship's concern is.
their power is over.
Right, my lord. My lord will serve notice.
You have to serve. The paper books, informal paper books, in terms of the earlier order, are being filed after due service upon the all right. You serve them, call the next.
So only state remains, my lord.
27. This is 20.
This can be taken. The passport.
You are for which respondents?
Respondent number, my lord, 2 to 25.
25. Informal paper books are being filed.
এটা এক নম্বর এটা দুই নম্বর
Number 28. তারপরে 39, তারপরে 39। Number 29.
Service is not affected.
Let us see, service is not required. We'll see if service is required. What is the order under appeal?
Petitioner filed a divorce case for annulment of his marriage. The respondent appeared but did not contested the application. And therefore the honorable court dismissed ex parte on the ground of the jurisdiction. And that is okay.
So they were not contesting there also.
Lordship. Opposite party did not contested the case. But the learned court dismissed the suit on the ground of not maintainability of jurisdiction.
Yes, so what is wrong with this finding?
Actually, my case is that there is ample jurisdiction of the honorable court as it would be shown from my marriage registration certificate. It was exhibited. From the marriage registration certificate, it would clear that the marriage was solemnized within the jurisdiction of the judicial magistrate, learned magistrate.
Registration certificate is dated?
Lordship, it was exhibited as exhibit number 1, which is page number 2 of the impugned order. Marriage certificate dated 28th of November 2023. It was overlooked by the learned trial court.
Page 2, para 3.
Lordship. Marriage registration certificate was exhibited. If honorable court call for the LCR, then it would be.
You have a copy of the registration?
No, I have a copy. At this moment.
There's nothing recorded where it has been solemn registration. Service has been completed.
Service is not affected. Can you fix it on next week? Can you make it next week?
So first appeal, then service will have to be. We thought that it was a mandamus appeal. Service has not been affected till date. So
Number 30.
Lordship, in this matter, I am on behalf of the respondent number 1 and 2, Lordship. Lordship, I am praying for extension of time to file affidavit, Lordship.
what this arises out of?
An order of injunction, my lord, which was modified at a time of after contested hearing, my lord.
After?
My lord, initially there was status quo with regard to nature and character, everything, my lord, but at the time of after hearing the application, it was modified, and if Lordship kindly comes to order. And the
Third
certified-
party interest.
Yes,
Only third
only
party
third
interest.
party was granted. They were carrying on construction work. The status quo
Where
was
is your
granted.
application?
My lord, application is at page 20. Page 11, my lord. My lord, this is the suit. My lord, page 20, my lord.
20.
My lord, application for injunction. since at the time of admission, this court has already restored the status quo order with regard to nature and character, man. I'm enjoying that interim order. my lord.
This court has already.
Yes, yes.
Which order?
First order, my lord. Order dated the 3rd February 2023. Such modification if the trial could be directed to proceed with the suit, my lord.
Then what remains? You want to file affidavit? Yes, Lordship. File it. Then what is it? How much time?
2 weeks, Lordship.
As paid, further 2 weeks time is granted to the.
Number 31.
Lordship, in the 31, I am on behalf of the appellant, Lordship.
I am on behalf of
In this
the
matter, Lordship, Tapas Kumar Bhattacharya is appearing, Lordship, online, Lordship, but
Yes.
Lordship, then he's supposed to appear on virtual mode, Lordship, but
Ask him to connect. Yeah, he is more than welcome to appear virtually. Records are also here. Yes, proceed. This is against the preliminary decree.
Lordship. Lordship, filed an application for substitute.
You are appearing without a file.
No, Lordship, filed with my senior, Lordship, he is on virtually, but due to connectivity problem, but
Neither you are appearing nor your senior is appearing.
senior is appearing, Lordship.
Where is he appearing? Irresponsible way of appearing. This is not the proper way. And you are appearing without a file. Very unique.
Lordship, finally, take them at the next week, Lordship.
Why? Every matter has to be adjourned. Just for the asking. Everything is complete, nothing is remaining. We just have to consider it now. Why should we adjourn?
If actually the respondent hearing has, respondent number 2 has died, so they has to substitute in term.
He doesn't know, he's not even, he's just standing here asking for adjournment. Respondent number 2.
Yes, my lord. This is the plaintiff number 2 in the suit, my lord. Suchitra Das. Paper book, my lord, first page of the paper book, the plaint. In the paper book, first page, the plaint is there. And the memorandum of appeal, my lord,
My lord will find it at page 147 of the paper book. Page? Memorandum of appeal, my lord. No, from the paper book, 147, page 147 of the paper book, my lord. Page 148 is the. Has any application been filed for substitution?
Lordship,
We have not received it. What is the number?
3 and 4, Lordship, can 3 and 4.
It's on the list. Right, number 31. And one of the. It is not on the list. Look at the memorandum of appeal. No, there is nothing on the list. Other part. What is the issue on substitution? Tell us. How much delay in filing the substitution?
Lordship, kindly Lordship, not today, Lordship.
You don't know anything. Only an unfortunate way of appearing in a court. Empty-handed, you are standing here. Come with the file tomorrow.
Lordship.
Bala is the plaintiff number 2. Who is plaintiff number 2? Sucharita Das. Suchitra Das. Suchitra Das. Substitution, my lord.
Where is the death certificate of Suchitra Das?
We have to provide it to them, but we have been.
But they did not provide me, Lordship.
How did you come to know about death?
No, can 3, my lord, is the substitution application for appellant numbers 1 and 2 who have died during pendency of the.
There is separate
appeal.
person,
Yes.
not Suchitra.
No.
It's Gautam Bala.
Yes, ma'am. Plaintiff number 2. Plaintiff number 2. Plaintiff number 2 has also died.
So how many are to be substituted? 2.
2 of the appellants have died and 1 respondent has died. So for the respondent, no steps have been taken. No, my lord. Then what is the point in having it tomorrow? File an application for that also. Respond number 3. For respondent 2. ma'am. Respond number 2. Suchitra Das. We are informed that respond number 2.
Gautam Bala and Shikha Paul.
Yes, they are the appellants before your lord, defendants in this suit.
Initially, they were the defendants, number 3 and 4.
Yes, my lord.
They have expired on 15th of December 2015. As for the endorsement in the.
My lord is referring to can 3 of the.
On the paper book.
The paper.
From the paper book. From the copy of the claim, page number 2. There is an endorsement to the effect that expired on 15/12/2015. 3 and 4. While 5 has expired on 19/2/2015. All have been substituted during the pendency of the suit.
But there subsequently 2 have also died.
That is what they have said. Now, my lord, Gautam Bala and Shikha Paul were not substituted, my lord, in the appeal. If your lordship kindly sees the memorandum of appeal, their names are appearing as the appellants.
It is dead person.
Filed by dead person.
Already substituted in the suit. Then.
Because it expired in the year 2016.
No, not to my
Please
knowledge, my lord.
clarify.
Yes, I'll clarify, my
Your
lord.
lordship is saying
Yes,
that
yes.
they are
It
substituted
is
in
there,
the,
my lord.
in the trial court, then that must be an typographical error or omission. Fresh substitution will not be required. It may be a case for amending the cause title.
This, my lord, subject to correction, this possibly, my lord, says ex parte against these two, against them. Ex parte, my lord.
Party against.
Because twice, my lord, it was put on ex parte board. Same operator. Great one. Number 32.
My lord, praying for not to develop.
He is sitting here only for granting adjournments today since morning. What is the matter? Can is pending, can 2 and can 5. What is can 2 for? It's already done. That's already granted. Service is complete.
I have no idea, my lord, my senior instruction. And please not to develop.
Number 33.
No, any newspaper has been filed, substituted service. Any newspaper has been filed. None appears on behalf of the appellant. List on this date of Thursday.
Number 34.
Your Lordship, service is not completed yet.
Let's see, what is it arising out of?
It's a divorce petition filed by the husband. We are behalf of the wife.
Service is not complete.
Yet, yes.
Same situation in January. Since January, service is not complete.
Your Lordship.
What steps have you taken in the meantime? After that, nobody appears. Service incomplete. Last day also you have sought an adjournment. File the affidavit. Why are you not filing the affidavit?
Your Lordship, actually, I have instructed, I'm just
I
instructed.
don't know what is going on. That's the whole problem. The service incomplete. There was an order in January.
Yes,
So what happened in the last 3 months?
that I have to take instruction.
Tell us. That counsel for the appellant should inform the court. Should file affidavit of service. Within a week from date. List on 29th.
Number 35.
Hello, I will have training for 1 day.
Not today.
Lordship, item number 36, I am praying for a day's accommodation, Lordship.
In the
Lordship, the London council was here before the lunch, but he was feeling uneasy, so he left. Lordship.
Then I am for the
Much
respondent.
I am appearing on behalf of the respondent number one.
Item number 37.
37 Millard, I am for the appellant Millard. This Millard is a,
37, today I am appearing for respondent number 1, 2 and 3.
I am-
Lordship, liberty may be given to file appearance opposition lordship before
Millard, I am,
hearing of an application.
Millard, along with my memo of appeal Millard, my application for injunction is there. Millard, I am praying Millard an ad interim order of status quo over the suit property. Millard, this arises out of a decree in a partition suit.
Preliminary decree.
That's it.
Their suit has been
It's a decree.
So
Although
against
decree, but
dismissal,
it's
you want,
dismissal.
against dismissal, you want
Millard, my sole ground is, Millard, the deed, the registered sale deed on the basis of which the learned court reached a conclusion that I had no title over the joint property, which I claimed to be my joint property. That deed is not existent and fictitious. Millard, I have annexed a certified copy of the deed. Millard would find that it is a completely different document. And this was not considered by the court itself.
There are many factors wrong, liberty was given to file our opposition lordship.
I have to file.
In their, Millard, in their evidence, Millard, they have said that they don't know about this registered deed, but the learned court will proceed to rely upon this document. And this has no connection with the suit property at all. Millard would take Millard's page 65 of my injunction application.
The lot of rights are different. Tendency has been already splitted out.
what is the date of the impugned order? And,
It's
Millard,
30th
30th
July
July.
2024.
2024. 30th July.
July.
30th July. 7/7/17 is, what is 7/7/17?
Who filed on 7/7/17. But the first page of my decree, Millard, in the decree, Millard would find below the valuation statement, suit filed on 7/7/2017.
File your appearance. Yes. On behalf of.
I am for respondent number 1, 4 and 5.
Respondent number 1, 4 and 5 has entered appearance by filing Wakalatnama. You are for 2 and 3. Respondents 2 and 3 are also present to their counsels. How many other respondents?
Milord, 6 and 7,
They are not represented.
they're not represented. Milord, in our, all the Milord track reports, it is showing item back, even for them.
So there is no service.
Milord, according to the track record, no. Item back for all the respondents, but it appears they
They
have
are
received.
appearing therefore.
They have received, so the track record may not
This will
reflect
not
correct.
cast a presumption that they
No,
have
no,
been.
no, I'm not.
So therefore 6 and 7, there is no service.
No service as well.
So take out a fresh notice.
Right, Milord, but kindly take it up in the next week, Milord, subject to Lordship's convenience, so that my prayer for.
No, but
interim
they will
injunction
also
may be
have to
considered.
file opposition. They
Let,
can.
let your Lordships consider my interim prayer, they can subsequently come back with their opposition to my application for injunction.
Interim prayer.
Let the learned counsel for the appellant take steps for. Take steps for fresh service of notice upon respondent number 6 and 7
6 and
as
7.
the earlier reports have not crystallized in any effective service. Full stop. List after 1 week.
Great.
Let affidavit of service be filed in this regard.
Grateful.
Within 2 weeks.
1 week, let them complete the affidavit. Next service.
Next week.
We can keep it whatever after that when. We'll keep it on the 1st of May. In the meantime, you do it. 1st of May. In the meantime, you do it and you file your opposition. Let affidavit in opposition also be filed.
First week of May.
To the CAN applications. 1st of May.
First May. Log out only.
Grateful.
Item number 38.
My lord, 38, I appear on behalf of the appellant, my lord. My lord, there is a defect showing till date in the cause list. My lord, we have already given the original copy of the decree, my lord. Previously, it was not annexed. That's why, my lord, a defect was showing. My lord,
Yes, it is removed.
yes, it is removed. My lord, this is an appeal, my lord. The learned trial could dismiss the appellant suit for divorce, my lord. An application was filed for adducing additional evidence. My lord, on 3/4/2025, a direction was given for serving the copy to the other side and the application will be taken up. My lord, I am praying for extension of the time. My lord, I may serve and come back. My lord, kindly, my lord,
3/4/25.
yes, previous circuit bench. Kindly fixed it on next week. I will do the matter.
You have not complied with the earlier order.
My lord, my lord. I'm praying for extension, my lord.
The other side has appeared.
No, my lord.
Any notice has been served on them.
No, my lord, I have to serve notice. My lord, I tender apology for that, my lord.
No, you are interested in serving application, a copy of the application, but why? Right. Take down. The time for affecting service in terms of the earlier order dated 3/4/25 is extended by a week from date.
Number 39.
Lordship, I am for the appeal, Lordship. In this case, Lordship, on 9th April, Honorable Court direct me to serve the copy and appeal was admitted and serve the copy to the opposite party. I have served, Lordship, but service not affected all the parties, Lordship.
There is no effective service.
Two opposite party not affected. Finally, fix the matter of next week. During this time, maybe it was affected, Lordship. One is Golgolia, Bihar, Lordship.
Which respondents have not been served?
Served, Lordship. I have served, but not affected, showing that the item not delivered. It is transit.
So the tracking is, the report is not showing.
Yes, Lordship.
As per the tracking report, it is submitted by the learned counsel for the appellant. That service is still not complete. They are seeking time. When we start dictating the order, then you say, it. Yes.
Well, it was the partition suit before the trial court, which was decreed. So 5 plaintiffs who rest of the legal heirs. We are one set of legal heirs, other set of legal heirs also defendants. One of those defendants is yet to be served.
Which defendant? Give us.
Well, I'll just find out. এখান থেকে দেখো গলগলিয়া defendant number 9 bit before the trial court, madam. Usha Ghosh.
And here, what is the position? Party position. Respond number?
Well, I will check
9.
it. 9.
So respond number 9 service is not complete. And what about the others? Who are you representing?
We are representing respondent number 1 to 5.
1 to 5.
Yes.
So then 7, 8, 9, 10. Served. So 7, 8, 10 has been served. Only 9 is not served.
Not served because they are living in Bihar.
How do you say so? It says district Darjeeling here.
This is the one apology, Lordship. Golgalia is the Bihar. Pin code is 8551.
How do you expect anything to be served on such an address?
Lordship.
Calcutta district Darjeeling and pin of Bihar.
Yes, Lordship.
So how it will ever be served?
One is there is a one.
So take steps to rectify this.
Lordship, I'll direct.
Yes.
Taking liberty.
So regarding 7, 8, 10, you will be filing an affidavit.
Yes.
And 1 to 5 you are representing. And what about 6?
6 also served.
So 6, 7, 8 and 10
9.
you will be serving. Regarding 6, 7, 8 and 10. Respondents number 6, 7, 8 and 10, the learned counsel for the
Actually, my lord, the trial court addresses that violation.
But there they were appearing.
They appear.
Something has to be done. That is a impossible address.
Absolutely.
Can't be.
But now I checked with the trial court record that I have with me. The trial court plaintiff has the same.
You will have to do something if you don't.
I will correct.
Item number 40.
Sorry. But service is yet to be affected. Only one respondent. Only single respondent, my lord. Grant me 2 days time, and next week we'll get served and get the matter. It is also against the decree for partition. Lord.
Number 41.
Lordship, item number 41, we have served the copy through speed post, but service has not been effected, Lordship. Kindly fix it on next week, my lord. Grateful.
For 42.
Lordship, in this, I am on behalf of the appellant, Lordship. I served all the respondent, Lordship, but all the post is returned, Lordship. Lordship, I need to direct you to file the fresh service, Lordship.
That we have efforts to serve the
Number 43.
My lord, I appear on behalf of the respondent.
yes.
My lord, they have served us a copy in WhatsApp.
Last occasion, there is a direction to serve the notice. I have sent the notice, but did not receive. No,
My lord,
only item dispatch
copy
in the.
will be given to us, my lord, kindly. Upper
Yes,
side.
Lord, I will kindly fixed Monday. Lord, I.
Tomorrow I will have hard copy. Evening of tomorrow, because yes.
Today upon the advocate.
Tomorrow. No, tomorrow, because I have at that time DP's one copy is having tomorrow, within tomorrow. Only one.
My lord, I will file affidavit in opposition regarding that, my lord. Till date, I am giving the maintenance to my wife. That is not written, I think so, my lord. I'm paying
But no
10,000 rupees every month. 12,000.
injunction.
That was already been granted.
Yes. Initially, I have initially I have sent, but they refused. Opposite party refused. It is mentioned in the order. Final.
Give me the hard copy so that I can also place my hard copy of the
Memorandum copy and
application.
I'm duty due. Yes.
And
Application.
applications. Injunction application and RP disposed of. I can put a feature.
Can one take.
My lord, then only the memorandum of application.
No, cannot dispose of. Not dispose of. Yes, my lord.
What is the order? Paragraph 5 of the order 745.
Lord, there is a direction to serve the copy of the order and application, my lord.
Casual appearance.
No, my lord, that is not affected by that.
Unfortunate appearance. See what is written in paragraph. Here like this. Is there for 2 decades.
day after tomorrow করবে তো? ঠিক আছে।
Number 44.
My lord, I'm appearing for the appeal. My lord. My apologies, my lord. My lord, the party, the respondent party has been served. I don't have it, my lord. I don't have it with me right now, my lord.
Number 45.
Lordship, I am appearing behalf of petitioner. Yes, Lordship, section 5 application needs to be filed. Yes, Lordship. Yes, Lordship. Lordship, I will rectify that.
In the defects.
Number 43.
Lordship, I'm for the appellant in this matter. At the outset, Lordship, I want to submit that this is a change bill. No, there are certain defects, and with our sincere efforts, we are not able to rectify the defects. To
Why?
remove the
What is
defect.
the nature of defect?
The nature of defect is that the name of the parties and valuation of appeal could not be verified. Now, what we can see is that, Lordship, that the cause title in the first appellant court has wrongly been named in place of the appellant. The plaintiff of the original suit has been arraigned. Now, we were supposed to file a decree, the original decree of the lower appellate court, but we are not able to get hold of that. Now, even then, Lordship, no rectification application has been filed by either of the parties in the court below.
The second appeal,
That it's a change brief, Your Lordship. So that is the difficulty that we were facing. Because at the time of filing, we went to see what the defects was found. The defect was that the name of the parties. And then what we did was we had to file a degree of the first appellate
what
court.
was the defect?
The name of the parties and valuation of the appeal could not be verified.
Decree of the lower appellate court has not been filed.
When the decree was not of the lower appellate court was not filed, we made an application for that decree. Now, when we filed the decree, they are saying that this particular person has not filed this appeal at all. So we went and looked through the original decree, and that can be found in the first appellate court, court's order, Your Honor, that the cost title is wrongly stated.
Where is that? First appellate court's photocopy you have enclosed.
I have. Towards the end.
Oh, but when you apply.
The certified copy. Now, this was a change brief, Your Honor. This was already filed. So when we try to file the decree, that was the difficulty. The judgment is there. This is just the judgment. Now, if you look into the order dated 21st day of December 2021, the name of the appellants here is Sarada Pradhan and Raji Pradhan, whereas they are the actual defendant. They are the plaintiffs.
This is the first appellate court's order.
They are the plaintiffs actually. Now they have been arraigned as appellants. And in the name of the present appellant, the second
Why?
appellant,
But what, they are supposed to be respondents in the first appeal.
they are supposed to be the plaintiffs.
So their suit was dismissed.
Their suit was not dismissed, Your Honor. This is against affirmation. They were the respondents in the first appeal. They were the respondents in the first appeal.
Where is the trial court's order? The suit's order, judgment? The suit was allowed.
The suit was allowed.
Then you are saying affirmed. There is no affirmation then. Oh, that
For-
has been affirmed by the appellate court.
By the appellate.
So in this, one of the clause that you have. That's what is wrong or the. So how do you propose to resolve this issue?
Either we have to file a review below the court below, asking to rectify the cost item.
How to review?
Recti-
error. Critical error.
Rectification petition.
It is up to you.
The only, I asked myself, Your Honor, whether it would be appropriate for us to file that rectification because it was their appeal, their suit.
You are the appellant before the first appellate court.
Yes.
Then no. Huh?
But our name has been added as respondent.
So therefore you are no, you are not aggrieved by this error.
Then we applied for a decree. We are not able to get hold of the decree.
Because there is nobody by this name as an appellant. So
Right.
therefore, we have to take some steps.
We'll look into that. You may
What
kindly
look
give
into?
it.
The appellate court's order judgment is of 21.
Lodge.
Last 2-3 dates, there has been so much of hearing in the matter. Nobody realized that there were so many mistakes.
we just came recently, Your Lordship. This is a changed brief. That's why that's also we will, Lordship.
This was during the lockdown. This law 21 is very.
Is submitted by the learned counsel for the appellant.
Item number 47.
Lordship, item number 47, I'm appearing for the appellant, Lordship. I'm led by Senior Advocate Mr. Amlesh. Actually, he's unwell. He's left the court. I'm only praying for 1 day's accommodation, Lordship.
Not today.
Grateful, Lordship.
Number 48.
This is in judgment and order of affirmance, my lord. Affirmance, my lord. The learned, the judgment and decree of the learned trial court has been, my lord, affirmed by the learned first appellate court. My lord, in respect of a title suit with regard to the declarations of the tenancy right of the appellant, lordship. My lord,
What has been held?
My lord, he could not establish his tenancy right. That has been held by the learned first appellate court as well as also the learned trial court. Whereas lordship, my lord, before that, my lord, my point, my substantial point of law is before your lordship that the landlord, my lord, initially they instituted a title suit in the year 1995, which is for the eviction suit on the ground of my lord defaulter and the reasonable requirement. My lord, that suit was dismissed in the year 2002. Again, my lord, they preferred another.
Filed under NCD6.
My lord, my lord, title suit 60 of 1995. Yes.
Filed
Yes.
under 1956.
Yes, your lordship. Yes, because that is the next one is 1997. 1997. So, my lord, that was dismissed on the ground of, that title suit was, my lord, for eviction of suit on the ground of reasonable requirement, defaulter, and subletting the suit premises. Now, my lord, that title suit was dismissed. The suit that suit for eviction filed by the landlord, who are the defendant in the instant title suit,
Yes.
that was dismissed.
Yes.
Now thereafter,
That was suit number?
suit number TS title suit 60 of 1995.
When it was dismissed?
Dismissed on 30th September 2002.
Yes.
Subsequently, lordship, they again instituted another title suit for eviction, that is title suit number 10 of 2006.
Yes.
That is also dismissed, although that was dismissed on the ground of non-prosecution. Now, lordship, in those two suit, my lord, that was it was admitted by the landlord that the appellant before your lordship is the tenant. Now, my lord, this instant title suit, that is title suit number 25 of 2008, it has been instituted by the tenant appellant, my lord, for my lord declaration of his tenancy right. Now, for lordship's kindly comes to the page 33 of my CAN 1 application, that is the application for stay. The issue has been framed with regard to.
This title suit 25 of 2008.
Yes.
Has it been filed by the original tenant or the legal heirs of the original tenant?
No, my lord, the legal heirs of the original tenant. The lordship kindly comes to page.
So section 2G comes into effect.
My lord, section 2G will not come to it, will come or will not come, my lord. That, my lord, before that, my lord, I want to draw your lordship's attentions with regard to page 33 of my CAN applications, CAN 1, stay applications. My lord, the issue has been framed. My lord, issue number 6 and 7, lordship can see.
Unless and until it is admitted, no other application can be taken up.
My lord, but my lord, in the earlier two suits, it has been established that the plaintiffs are the tenant, lordship.
Herein, unless the second appeal is admitted.
Yes.
No other application can be taken up.
No, my lord, this is the stay application, my lord. My lord.
Has this been admitted?
Lordship, in that case, lordship, kindly see the memo of appeal. There also, my lord, I have annexed the or the judgment of the learned trial court. But I'm not taking the stay application. Lordship kindly comes to the memo of appeal. Even lordship kindly comes to.
So you are pressing upon admission.
Admission. In that case, lordship kindly go through the memo of appeal. Page 20, the certified copy, yes,
as regards to the stay application, which you are mentioning.
Yes.
That is not in the record.
For the convenience, lordship.
That is not in the record.
That is not in the record. That I don't. CAN 1.
Let us.
But logically comes to the judgment and decree of the learned trial court. That is my lord, the certified copy, page 21, 22. First time.
Wherein the prayer of the landlord was dismissed.
No. I am referring the issue framed in my title suit. In my title suit. That is title suit number 25 of 2008.
First of all, we have submitted that in the first title suit.
Lordship, everything will be clear if your lordship can go through the issue. Yes.
You have submitted that earlier two title suits were filed.
Yes.
The first one was dismissed.
Dismissed.
Therein, the issue of relationship was decided.
Yes.
Where from we will get that now?
My lord, that document is not, my lord, that document is not in my hand, my lord. It will be evident if the lower court TCR will come, lordship. Before that, lordship, that's why I'm trying to draw your lordship's attention with regard to page number 22 of the certified copy of the judgment of the trial court in title suit number 25 of 2008, which has been filed by me, the tenant. Page 6 and 7, issue number 6 and 7. How much TS number 10 of 2006 is binding and relevant in deciding this suit? 7 is how much facts and circumstances of the title suit number 60 of 1995 are binding and relevant in this suit. But these two issues have been framed. Issue number 6 and 7. Now, if your lordship kindly go through the judgment, my lord, while dealing with these two issues, not a single word has been uttered by this learned trial court whether these two suits are binding, whether the observations these suits are guiding the present suit or not. Lordship kindly comes to the very next page, page 24, issue number 4 to 7. These two specific issues have been dealt with the other issues in a very general manner. Nothing, not a single word, my lord. All the issue has been framed. So, my lord, the trial court record is required to be, my lord, brought. May I read the entire issue, lordship?
When did the earlier plaintiff, the defendant die? Who was defendant in the earlier suit? What is the date of his death?
I have to take instruction, my lord. Today I'm not really ready, your lord.
Then you tell us, because the issue of 2G has been raised by the court and it has been considered. So that the only relevant issue is when he died.
Yes, that is true, my lord.
So
but
give us that date.
My lord, my humble submissions before your lordship.
We have understood what you are saying. Yes.
My lord, the right of the locus of the appellant has been established.
No, locus of the appellant's ancestor has been established. Therefore, we are asking you, what is the date of death? That is the only relevant thing now.
I don't know, lordship.
Yes, as paid,
I'm taking all instructions.
the issue, as paid by learned counsel for the appellant, that is that.
Number 49.
My lords, for the
My lord, for item number 49 and for the respondent number 1.
my lords, I'm for the appellant.
Certified copy does not contain the list of dates.
My lord, the
The
certified
limitation-
copies.
The limitation could not be considered. It is a defective matter, how I am proceeding.
There is a delay, my lord. We have preferred an application for condonation of delay, my lord.
Delay of how many days? And from where do you get the calculation? That is what is to be seen. So normally at the back, you have the date on which it is readied and which is notified and when it is handed over. There is no such details. But this order was required to be sent down to be corrected.
A delay of 18 days, my lord.
From where do you get this? What is the basis for such calculation? Order is of 30th September 23. No.
I have the entire bunch of the order, my lord.
Live, ready, nothing is there notified.
Malad,
Certified copy unless it is, unless it reflects these things.
I think I have committed a mistake at the time of filing, my lord.
Oh, you have not, you have submitted a wrong certified.
No. Certified copy is right, my lord, but I have not supplied the first copy.
So therefore,
Where-
these details
yes,
are lacking.
Yes, because it contains other documents also. So, my lord, I shall submit it before the department.
Do it,
My
yes.
lord. And my lord, moreover, the talks of settlement is going on between the parties, my lord.
As per the instruction, the talk of settlement is.
All right, that is.
But I shall hand over this document.
At least you complete this.
My lord. My lord.
The first. As per the submission of the council.
Yes.
Next. You are appearing in both.
Respondent number 1.
Give your appearance.
Second number 50.
Same order. Same order.
Number 51.
Membership service not completed. Kindly put this matter on Friday. Kindly put this matter on Friday. Service not
This is
completed.
incomplete as paid. List after 1 week.
Number 52.